Welcome to the new year with the League of Women Voters. I'm Beverly Bean, the president, and we look forward to an excellent program today. I'm going to leave it to Janet to introduce our speaker.
So it is a great deal of pleasure that I introduce our speaker, Gary Patton. Gary was a supervisor in Santa Cruz County for 20 years. He has a wide variety of experience. He served on the Air Resources Board, the California Coastal Commission. I first met Gary when he was my boss at the Monterey Bay Unified Air Pollution Control District. Gary was the first executive director of Landwatch Monterey County, which was about 16 years ago. He has participated as executive director of PCL. He was counsel for the Planning Conservation League. He's now on the board of the Sierra Club of the U.S. State Sierra Club. He is an attorney and he is of counsel to a law firm in Santa Cruz. He has been on both sides of the issue of government, both as a government participant and as somebody working with nonprofits and working to make sure that government operates in an open and fair way. And he is an expert on all the issues that we will be addressing today, which will address how to keep government honest. So with that, I would like to introduce Gary Patton.
Well, my name is Gary Patton, and I am just so pleased to be back in this room and back with the League of Women Voters, and I really do very much appreciate the opportunity to speak, and thanks for having me back in Monterey County. You know, I was across the river there in Santa Cruz County as a county supervisor for 20 years, and when I came over to Monterey County as the Landwatch executive director, was dealing mainly, not only, but mainly with county government, and it was quite a different proposition over on this side of the river than from in the Santa Cruz County side of the river, but I learned to love it over here too. And I am going to talk today on the topic assigned, keeping our government honest, or how to keep the government honest. How do we do this? And essentially, I'm going to try to focus in on four major laws. First, the Ralph M. Brown Act. Secondly, the Bagley-Keene Open Meeting Act, which applies to state agencies. The California Public Records Act, and a conflict of interest and disclosure laws affecting public officials. And what I'm going to do really, and I'm going to try to not speak so long that there won't be time for some interchange, because in fact, while they're at one level, these are very, very simple laws. They set up some very basic rules, and I'm going to probably be articulating mainly the basic rules. There are, as you could expect, and as you've probably experienced, being that many of you are with the League of Women Voters, a number of incredible complexities with these laws that are supposed to keep the government honest, that somehow it turns out it doesn't work that well. And so I am hoping we can get into a little dialogue and discussion with any specifics that you may have. But before I start going through the basics of these four areas of law that will help us keep our government honest, I would like to just present to you the idea that we need to think first about the real nature of this government that we're trying to keep honest. And you would think that we all know that, but I'm not certain we all deeply appreciate the nature of our own government. I did not appreciate it, although I went to law school and got elected and was in a campaign. When I first took office in Santa Cruz County in 1975, I didn't understand what it meant to be a member of the Board of Supervisors in the sense of what is really the nature of that job and what is the nature of government. And so maybe you will have thought about this, or maybe you won't have, but let me just tell you how it is from a board level, just using that agency as an example. There are 5 members of every county board of supervisors, except the special case of the city and county of San Francisco. And those 5 members vote virtually every Tuesday. It's almost a weekly cycle. There's some vacation times. But basically every week on Tuesday, you vote as a member of the board on a whole host of items from the sublime to the ridiculous. And things like, should we spray pesticides on county roads, or should we raise the salaries of nurses, or should we allow a new development project? All sorts of things. And you need 3 votes to get something to happen. Most things happen unanimously, but sometimes on big issues there's divisions, and you need 3 votes to win. And so you do that. Week by week you do that, and then I think all board members are like me. On Wednesday you want to read what they said about it in the newspaper, because you took some action, and particularly if it was a divided vote, what do they say? Well, what they say is something like this, just whether in editorials or news stories, headlines, something like this. Yesterday, the county banned 3 strong 3-story developments near the harbor. Or, news story, county spends its money to prevent offshore oil drilling. Or city and county agree to disagree. And I don't know whether you pick up on this, because I didn't until I'd actually started serving in this role, but they are saying that the Board of Supervisors is the county. They're saying that the city council is the city. And in fact, that is not a mischaracterization. And this is the revelation that came to me literally during my first budget hearing, when I almost got sick physically because I wanted to be a good public official. And my first budget session, which was in June of 1975, there were 3 votes on the board. It was a very contentious and divisive budget hearing that took $1.2 million that the county administrative office had designated for various purposes and moved that money in $15,000, $5,000, $25,000, $30,000 grants to a whole host of community-based nonprofit groups. And that was very contentious. The CAO did not recommend that. 2 members of the board were dead set against it. And we took our money and changed the way it was being spent. And in the middle of doing this, highly emotional, the room was packed, sort of like this room, with my friends. And I look out there and I see them. They were going to get the money if I voted yes. And I started voting yes, and then I began thinking, what am I doing here? I'm just giving money to my friends. Isn't that what I hate about politics and government? It's just giving money out to the ones you like, and isn't there some better way to do it? Or is this really right? And I had an almost physical reaction, and then it dawned on me, with the other 4 members, I am the county of Santa Cruz. I get to decide what is the right thing to do. This is my job. These guys, who are my friends, are doing good things. They're going to take care of child care issues. They're going to address community gardening. They're going to start the Gray Bears program. They're going to do all sorts of things if I vote yes. And that's why I'm here, is to do something that I think is right, because I am essentially the county. Well, that is correct. The county is those 5 people, or the city is usually 5 to 7 people. They are the government. They are the community. Their limitation in terms of action is constitutionally, if they try to deprive somebody of due process of law or their property without going through the right steps, they can't do that. They can't violate their own laws, and they can't act outside their jurisdiction. But within the jurisdiction of these agencies, these governmental agencies, the elected officials are the government, and they are not only the government, they are what the government, the community that the government represents, whatever that is, a county, a city, a district of some kind. So the first thing you need to realize, if you want to keep the government honest, is that the government is not some reality that exists independently of the elected officials who in fact are the government. They are the county. 3 members of a board of supervisors are Monterey County, and what that means is that politics is what keeps government honest. And frankly, lots of people hate the government. Lots of people don't really like the government, but they think it's sort of a necessary, if not evil, it's a necessary thing. But they really don't like politics, because politics is seen as this very dirty, horrible activity. And yet, if you think about government, which is like, I always use the metaphor of steering the ship of state. Which way are we going to go? Are we going to turn? How fast are we going to get there? What is our objective? Steering the ship of state, governing the direction that we go as a community. How does that happen? It happens this way. First, there's all of the debate and discord and controversy and conflict, because while we're all in Monterey County or all in the city of Monterey or Seaside or Marina, wherever, lots of different views there, lots of different interests. So while we're all the community, when we want to make a decision, there's got to be a process. The process is politics. And all the conflict and controversy, debate and discussion leads to a decision. Sometimes it's an electoral decision electing a representative. Sometimes it's direct democracy. But in essence, politics leads to a decision, and the decision leads to law. Now, I'm a lawyer, so I like the idea that law is in there. But if you really think about how it works, whether it's a regulation, a rule, a minute order, it's some written instruction adopted by a majority of the governmental entity that is like a piece of paper you hand to the executive officer or the city manager, the department heads. Their written instructions of what to do. Spend this amount of money to do that, et cetera, et cetera. Politics, law, government. And so, if you actually want to keep government honest, you have to enter at the political level. And lots of people don't like that. They need to get over it, because our problem oftentimes isn't with the kind of things I'm going to talk about. It's with the failure of our communities to become political enough to demand that the people who are our communities, who act for us, who have plenary power to do whatever they want, actually respond to what the public as a whole wants. And that's almost a full-time job as a citizen to do that. And anybody who thinks that you can have an honest, good, responsible government without you directly and personally spending a significant amount of your own personal time involved is making a big mistake. And that is what has gone wrong with government in most places everywhere in the United States, is that we have somehow come to believe that it's independently, that it exists independently of our own political action. So the first rule, get into politics if you want to keep government honest. And the second rule, like unto it, is don't let them tell you there isn't any choice. Because that's what you hear from these government officials, the department heads, that, you know, gee, that sounds like a good idea, but really there isn't any choice. I mean, that's just the way it is. It has to be that way. There's some law, there's some rule, there's some reason, there's some tradition. It's got to be that way. So whatever it is you want to do, can't do it. Just understand that, and I write a daily blog called Two Worlds. There really are two things, the two worlds that I say we live inside of. One of them is the world of nature, the natural world. And indeed, in the natural world, They're laws, and they are inevitable. They state inevitabilities. If you throw something up in the air, it falls down according to the law of gravity. You don't have any choice about that, and if you violate those laws, you find out to your detriment what happens. And we are finding out because we're trying to break those laws. But in the political arena, in the political world, in the world that we create through this politics, law, government system, anything is possible. You can do anything. And we've made lots of past choices. There's lots of momentum. It's not easy, but technically speaking, you don't have to do anything the way it's being done now in the world of our political life together, which is mostly what we live in that world immediately. That's the world that really we inhabit. The world of nature is what makes it all possible. We need to worry about that. So, I make this prefatory speech because getting too quickly into the rules and regulations that we currently have to try to govern ourselves and keep our governmental process honest doesn't get to the core question as far as I'm concerned, which is, do we have an idea of what we want to do? If we do, are we willing to spend enough time to organize, to take over a majority of the board, the city, the water district, whatever it is, and do it? And have the courage to do it. That story I told you was a real story. It takes courage to vote against the CAO. You're brand new. You just say, I don't care what you say, that you need to spend the money on this and that. I'm giving it to this little group because I think they deserve it. The idea that your local elected officials would do something new that's never been done before, that you think is better, it's not easy to get that to happen, but that's how you keep the government honest, because really what honesty means ultimately is our government reflects what we as a majority in the community want. It will never reflect what everybody wants because there are differences, and we fight it out through politics and make those decisions together. And if we're unwilling to get involved in the conflict and controversy, we're never going to have an honest government, because the government honestly won't respond to what the majority of the people want. Okay, so now we're going to go back to what I'm sure you all thought I was going to talk about, which is the Brown Act and the Bagley-Keene Act, etc. And you know, for those of you who would like to have a written reference, I actually have a so-called PowerPoint presentation that summarizes these things and, you know, has it in written form. So anybody who wants to follow up with me on any issue specific or get a copy of this presentation, just send me an email, and the address is this: GAPATTON@mac.com, and I will send you that, so then you can know what I'm looking at as I'm talking. The Ralph M. Brown Act, first adopted in 1953, is probably the most important foundational law to keep our government honest. It basically says, and it starts at the government, it's in the government code. Most of these laws are in the government code. It starts at government code section 54950. The legislature finds and declares that public commissions, boards, and councils, and the other public agencies in this state exist to aid in the conduct of the people's business. It is the intent of the law that their actions be taken openly and that their deliberations be conducted openly. The people of the state do not yield their sovereignty to the agencies which serve them. The people in delegating authority do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so they may retain control over the instruments they have created. That's the basic concept of the Brown Act. The basic implementation of that is actions must be taken at an open and public meeting. You cannot say something at the comments and referrals section of the Board of Supervisors agenda, which is what happens every week at Monterey County, and then somebody goes off and does it. It has to be voted on, and it has to be done in public, and that if you don't do it that way, you're violating the Brown Act. A meeting is essentially a majority of the people being in one place at one time discussing or deciding an item within their jurisdiction. And the law has been amended since 1953 to make very clear you can't do it indirectly by, hey, I'll go talk to Supervisor 1 and we'll get together on something, then he'll go talk to Supervisor 3 and they'll get together on it, and then we'll figure it out, and then when we have the board meeting, it's already been decided. You can't use committees to do that. You can't escape under the Brown Act the obligation to do your discussion and deliberation and decision-making in public. And when you have those meetings, the public has a right to be there, and it has a right to speak and to speak out. In other words, to be very disagreeable. You don't have to be nice. And that's important because you don't always feel nice and you don't have to be nice. For instance, Government Code Section 54954.3c says, the legislative body of a local agency shall not prohibit criticism of the policies, procedures, programs, or services of the agency or of the acts or omissions of the legislative body. You can go there, and if you've ever been in one of those meetings and you start ranting on about how they're just really doing the bad things, they often try to shut you down. Unfortunately, in my opinion, the law does give public agencies the right to very narrowly circumscribe how much time you get to speak, but they can't stop you from speaking. They can't do anything by secret ballot, incidentally, but you don't have to reveal who you are. You don't have to tell them who you are. You don't have to write your name in any book to be able to speak. If any public agency ever wants to make you sign in to be able to participate, do it if you want to, but you don't have to do it. There are some exceptions to this open meeting concept. Closed sessions, they're called. One of them, which is very common, is real property negotiations. If you're going to try to buy something on behalf of the government, you don't want to let the people who own the property know how much you're willing to pay. You got to determine that. Obviously, you send a negotiator out how much you're willing to pay for this property. If you say in public how much you're willing to pay, you're definitely going to pay at least that much, and maybe you could get it cheaper. You can talk with your attorneys to have the same benefit as a public agency that any individual talking with an attorney has, which is the confidentiality and privacy abilities. You know, the attorney-client privilege, it's often called. Now, in Monterey County, just to let you know of something that irked me no end when I was the executive director of Land Watch, the Board of Supervisors went into closed session to meet with their counsel about a lawsuit that had been filed against the county by, I think it was the Rancho San Juan Development Group, charging that the county was treating them badly. It was the biggest development, I think, at that time in the history of Monterey County or something like that. It was a terrible development from the Land Watch point of view. And they didn't just meet with their attorneys to talk about the lawsuit, they brought in the entire planning department. They planned a whole new development, right down to the road alignments, in the closed session. They then came out of the closed session and a public hearing so the public could react to this. The public didn't like it very much, but they voted for it. That is not really allowed. So there are some exceptions, but basically, and there are lots of intricacies of how things go, but the Brown Act is the basic statement that everything has got to happen in public, and the public has got a right to be there. The public has a right to know ahead of time when the meetings are going to be. It has a right to get the agenda ahead of time. It has a right to tape and take videos, to speak, to criticize, all of those things. Now, you may have heard something that the legislature suspended the Brown Act because of fiscal issues. And there are rules applicable in the state that say, hey, if the state government puts a mandate on local government, if a state law tells a local government to do something but doesn't furnish them the money, they don't have to do it. And so there are suspensions of certain portions of the Brown Act having to do with posting agendas. I don't think most agencies have utilized that suspension, but the basic provisions of the Brown Act are not suspended, and they can't be suspended. And if you get my little summary, you can see some citizen guides to the Brown Act to make it easy to understand. But I definitely encourage you to look at the law and read the law, because we need to know the laws, or we can't as citizens really effectively participate. And you don't have to be a lawyer to understand English. You can read it, and it's pretty clear. It may be complex, but it's clear. Incidentally, I have just found out earlier today that there's a big controversy at Fora about Brown Act meetings, and is something being done correctly under the Brown Act. And Fora is not directly elected. It is an agency in which elected officials serve, but they're appointed to the position. It and its committees are also absolutely subject to the Brown Act. So just don't let the government get away with anything. Just that's really the message of the Brown Act. They have to do it in public, and you have a right to be right there and complain about it. The Bagley-Keene Open Meeting Act, the second law I just want to touch on, and I'm not going to really do anything but tell you that it also is in the government code at section 11120 and following. That is a law very similar, though not completely identical, to the Brown Act, and it applies to state agencies. So like a fair board is actually a state agency. So if you ever wanted to deal with the fair board, you'd probably be dealing with the Bagley-Keene Act, but the statement of purpose is very much the same as the Brown Act. The remedies are very much the same. And by the way, in the Brown Act situation, this is a place where actually I think it is different from Bagley-Keene at the current moment. When there is a violation or a threatened violation, the district attorney can bring actions, but a citizen can bring actions to set aside actions that are taken in violation of the Brown Act, and or to prohibit actions in the future that are violating the Brown Act. Because if you've got a pattern and practice of committees that are meeting without the proper notice and just making decisions, and then the board putting them on the consent agenda, or the city putting them on the consent agenda, or Fora just voting on them without having the full public hearing process, you can actually get a court injunction, and if you win your case, you probably get your attorney's fees. Just last year, there's a new law that actually tries to shortcut the necessity to sue, because you can now send a letter if you think that there's an agency that isn't following the law, they've got some practice that isn't appropriate. You can send them a letter and say that we are asking you to cease and desist. They have a certain time to do that, and if they do it, then they have to cease and desist. If they don't, then you can sue them, but it lets the local government agency avoid a lawsuit, which otherwise there was no remedy. I mean, the citizens would just shut up and sit down, or they have to sue you. Now you can send and say, look, you're violating the law, check with your attorney and cease and desist from doing this. And then if the agency is a good agency, they will cease and desist, and they can save everybody a lot of time and money. So that's a new opportunity, and in areas like Fora and so forth, that may be one that people would like to look at. The California Public Records Act is sort of the number 2 big issue for those who care about open, honest government. Because just like the Brown Act and the Bagley-Keene Act say meetings, all decisions have to be made at meetings, the meetings have to be public, they have to be announced, people have the right to be there, it's all got to be open out front. The Public Records Act says that the information used by, possessed by, consulted by any governmental agency is a public document. And that is in the Government Code 2, section 6250 following. In enacting this chapter, the legislature, mindful of the right of individuals to privacy, finds and declares that access to information concerning the conduct of the people's business is a fundamental and necessary right of every person in the state. All public records are presumptively open and public, and a public record is any writing containing information relating to the conduct of the public's business prepared, owned, used, or retained by any state or local agency, regardless of physical form or characteristics. And that includes, for those interested in land use kind of issues, the consultant's work done for the county, the city, the agency. Those consultants sometimes keep things in their offices. They're not in the county center or the city hall. They're in the consultant's chambers. But if it's a document relating to the public business owned, used, or prepared for the public agency, that's a public document. Writing includes everything. The public records that are writings are available, and a writing is any handwriting, typewriting, printing, photostating, photographing, photocopying, transmitted by electronic mail or facsimile, and every other means of recording upon any tangible thing, any form of communication or representation, etc. It's plenary. So anything is available to the public, and you've got the right to get those records at any time. There is a process for acting for copies, but the basic promise of the California Public Records Act, Section 6253, is public records are open to inspection at all times during the office hours of the state or local agency, and every person has a right to inspect any public record. Now, that means you should be able to walk into a public office and say, I'd like to see whatever you'd like to see, and they should give it to you then. If you want a copy of it, it may take them some time to pull it together to get it to copy. They do not have to do research for you and sort of write up something for you, but if you can identify a public document, you have the right to inspect it immediately and to get a copy of it in a fairly short time frame. They have 10 days to react to a request for copying, and the cost that the agency undergoes to get the materials together is not something they can charge you. They can charge you like 10 cents or maybe a quarter a page for the actual copies you get, but they don't have the right to say, well, that's going to take a lot of staff time, give us a deposit of $5,000 and we'll get right on it. That isn't how it works. Here's something you probably didn't know. Government Code Section 6253.1a says, when a member of the public requests to inspect a public record or obtain a copy of a public record, the public agency, in order to assist the member of the public make a focused and effective request that reasonably describes an identifiable record or records, shall do all of the following to the extent reasonable under the circumstances. Assist the member of the public to identify records and information, describe the information technology and physical location, provide suggestions for overcoming any practical basis for denying access. In other words, you will sometimes get resistance when you go in and say, I'd like to inspect the records or get a copy. In fact, that's been my experience. They try to say, go away. You know, we don't have that here, or that's out of our control. They're actually under a legal obligation to help you figure out how to get what you want. And that's a very significant commitment. There is a law firm in this community, Michael Stamp, law offices of Michael Stamp, who's made a specialty in California Public Records Act and to some degree Brown Act kind of issues. And I can't remember the money sums that this great law firm has recovered from time to time from agencies that are recalcitrant, but in Monterey County at least, I would think that local government agencies would understand that if they don't help you, they may get sued, and if they do get sued, they're going to have to pay. And so let's just hope that they will be more helpful in the future. Conflict of interest and disclosure laws, also in the government code at section 87-100 and 87-200 and following. No public official at any level of government can make, participate in making, or in any way attempt to influence a governmental decision in which he or she knows or has reason to know he has a financial interest. So it's not a philosophical interest. You know, when I was on the board, I was a very outspoken environmentalist, very much for social justice issues. Sometimes people would get up in the public comment periods and say, you know, Gary, Patton, you should be stepped down, you've got a conflict of interest. You campaigned that you wanted to shut down development on the North Coast, and this is all about that, so you've got a conflict of interest because your mind was made up before this hearing. That isn't a financial interest. That isn't a conflict of interest. That's politics, and that's what I was encouraging you to understand you should do, is elect the people who will agree with you, and then they'll do the right thing, hopefully, although that isn't automatic either, unfortunately. At any rate, a financial interest is defined in the government code, and it's essentially if it is reasonably foreseeable that a decision will have a material financial effect, not a general effect, but a specific effect on any business entity in which the public official has an investment worth $2,000 or more, any real property in which the public official has a direct or indirect interest worth $2,000 or more, any source of income, with some exceptions, a business entity in which the public official is a director, officer, partner, or holds any position of management, or on any donor of or any intermediary or agent for a donor of a gift or gifts aggregating $250 or more provided to the public official 12 months before the decision is being made. So you've got a financial conflict of interest if your decision could affect something that would affect you financially, or your employer financially, or somebody who's giving you presents financially. Disclosure is the next topic, because you can go look at these financial disclosure documents. The board members, the city council members, the elected officials have to file disclosure of their financial interests, of what is their income, what is their real property, what is their employer, so that these things can be tracked. It's sometimes very hard to make it all work out. These are not really scrupulously filled out by most people, in my experience, so you have to be on top of it. But you can complain to the FPPC, which is the remedy. There's an administrative remedy if there's a violation. I do have a whole bunch of references. If you want them, send me that email, and I will now talk with you about any questions you have. Ms. Brennan.
We have a current situation where a member of the Board of Supervisors serves on the Water Management District and was going to serve on the mayor's joint powers agency. And it's my understanding this conflicts with conflict of interest provisions in the legislation. Can you address that issue?
Yes, and that's not exactly a conflict of interest. It's incompatible offices, probably, because I don't know the specifics of this situation. But in fact, you can't hold incompatible offices. That's also prohibited. And so if some public position you have really relates in some way to some other public position you might have in a way that it would really provide a benefit or a possible benefit or the appearance of a conflict of interest, that is prohibited. And there are a good many, sometimes there are Attorney General opinions on this. There are a good many cases on that, and it's often a case-by-case thing of whether that incompatibility exists. But that is certainly another way to make sure that our government is honest, is making sure that people don't have these incompatible allegiances, which ends up in sort of agency self-dealing, cutting the public out of the equation.
What do you do if you know that there's a violation occurring, such as against the Brown Act?
Well, here's what I would suggest. Number one, if at all possible, get organized with others, so it's not just individual, but every individual can act individually. The first thing to do is to essentially object. One thing in law, particularly in governmental and agency law, is you want to have made the record that you tried to get it dealt with before you go to court. And so you try to get them to correct it. Write them a letter. It's got to be in writing, so it's part of the record. If they are not responsive, talk to a lawyer or read the law and do it yourself. You can then, certainly you can go to the district attorney, see if he'll prosecute. Often he won't, basically on the basis that there's prosecutorial discretion. They got lots of things on their plate. There are people getting mowed down in the streets of Salinas every day. They don't have enough time to deal with some obscure Brown Act question. You can go to the grand jury and try to have somebody do it. But ultimately, if you've got a strong and solid case where there's really definitely proof that they violated this law, I encourage you to sue the government agency and then win. And when you win, they're going to pay your attorney's fees, and probably the decision that was taken in violation of the Brown Act will be overturned. Yes?
Just a clarification. The public agency is only the elected public agency. The appointed ones do not count, like the police department, things like that.
Well, the police department is a public agency, and so, for instance, the Public Records Act applies to them. There are exceptions to the Public Records Act. I didn't try to read them because they're really a long list. And one of them has to do with criminal things, of many, many kinds of criminal things are not, you can't go get the criminal records of your next door neighbor just because you'd like to look at them and inform yourself, even if it's a governmental record. But no, agencies of government at the departmental level or the subsidiary level are subject to these rules we've been talking about. The Brown Act talks about essentially agencies, and they're not only elected, but certainly elected is where you start. The meetings and the decisions of governmental agencies, whether appointed or elected, are subject to the Brown Act. The California Public Records Act applies to every agency, state, local, and including their subsidiaries. But there are lots of exceptions. You can't go get real estate appraisals at the treasurer's, at the assessor's office, so that you can, find out sort of private things. There are lots of exemptions. So if you're interested specifically, you got to be careful. But the basic rule is everything is open to the public. Yes?
Do you have statistics on how often a government agency's been sued for Brown Act violations? What's the percentage of those who win the case and actually can pay the lawyer afterwards?
I do not know that. My bet is this, and what I do is read the papers and so forth. I have an impression that in Monterey County, over half of the time that there's a lawsuit on these issues, the petitioner, the plaintiff, wins. But that may or may not be correct. I bet Michael Stamp actually would have some hard facts on that as opposed to my anecdotal understandings. Usually, if a lawyer's involved, a lawyer will not take the case unless it's a very good, solid case, because they don't like to spend a lot of time and lose. And also, their clients don't like to spend a lot of money if they don't think they're going to get paid back or so forth. So usually, these cases are fairly rare. And that's why when they're filed, I think half or more are successful. That's my impression, but I don't have statistics. Yes?
In our current water situation, there's a new agency, joint powers agency among the mayors. Their structure is obviously in public, and that's okay, but they form what they call subcommittees as opposed to committees. And it's not just a subtle difference.
No.
And I would like you to expand a little more on that, because it's important.
One of the ways that governments, in governments, this is why people are mad at government and don't like government and so forth. The governments are not welcoming. They're not trying to help you. They're not trying to encourage you to participate. They believe that the ordinary public is getting in their way. They're off base. They're just raising extraneous things. So they try to find ways that they can operate consistent with the law that diminishes the ability of the public to be effective. And this sort of subcommittee concept is one way of doing that, because a subcommittee that is less than the majority, as long as there's no communication with other members of the body, does not have to follow the Brown Act, and therefore it could go off and have lots of meetings, not notice them, and come up with a whole plan and then bring them to the agency as a whole. And that would have to be done in public, but basically kind of work out all of the kinks in private and sort of get commitments, at least supposed to be just with the subcommittee. And a lot of times there'll be this very hard to trace communication that really is a serial meeting. It's a violation of the law, but it's very, very hard to prove. If there is a committee that has to follow the Brown Act, and it makes a decision subject to the public participating, and then that decision is not changed and just sent to the whole body, at that point, the whole body doesn't have to hear further from the public. In other words, the Brown Act does say, look, if you have committees that are real committees and that are Brown Act committees and that go through the public process and come up with a recommendation, then when that recommendation goes to the whole board or the whole agency doesn't have to go through that process again. But subcommittees are different. It has to be completely new debate and discussion under the Brown Act. But you have put your finger, I think, on one of the ways that governments are trying to get around it, because you can't have serial decisions. But, and being an elected official, I have a certain degree of sympathy with this. How could you prevent 5 members of the Board of Supervisors, to use that example, from talking about important public issues? In other words, nobody wants to bring something to the board for action if everybody else on the board, probably nobody wants to, thinks it's a stupid idea, or before kind of knowing what the possibility of problems would be. And so you would go around and talk to people, and without actually having a meeting, you kind of know what's going to happen and so forth. And that's really what is going on in these cases. Usually they're protecting themselves legally, but the decisions are being made behind the scenes, and all of the answers to the controversial questions are being decided. And the only way around that is the political route, in my opinion. It's not very easy to attack it legally. Yes, Nancy?
Following up on Georgia's point, the subcommittee, if they have a consultant report that in effect might have written the report that the subcommittee is going to present to the full board, once it goes to the board, that consultant's report is then public records.
Yes. Draft materials are exception from the Public Records Act, so if the planning department is rewriting the regulations and they're passing around drafts to see, or the consultant's giving them a possible new approaches, a lot in the water area with new possible ways of drilling in aquifers and stuff, and what are the geological problems. As long as it's all a draft, those are not immediately exposed as public records. But once it's going to support some action at the board level, it's a public record. Yeah.
Are there any restrictions or limitations to speaking to or meeting with the public employee or staff person?
No. No. And in fact, one of the things I should have emphasized and I didn't is a lot of these restrictions, like, or the things that benefit the ability of a public agency to take action in closed sessions or to discuss things out of the public's view, are permissive but not mandatory. In other words, just because you're talking to your attorney, you don't have to talk in a closed session. You have the opportunity to do that, but wouldn't it be nice to share the wealth here so that the whole public understood what the legal ramifications are? Now, if you're talking about a lawsuit and the people who are suing you are in the audience listening to specific legal advice, that's one thing. But that oftentimes there's a whole bunch of sort of general statements by lawyers or others that are made in closed sessions, and then the public never finds out about them, and it's all permissive that it's going to be in a closed session if it's, for instance, an attorney-client type of a situation. So you can talk to anybody. You don't have, a public official or a public employee can talk to you. They don't have to, but they can. There's no prohibition on that. And essentially, again, what really opens up the political process is organized political activity, because these 5 people who are the county, or the 7 people who are the city council, or the people who are appointed who are the FORA board or the water agency boards and so forth, ultimately they realize that they are there only because the public has given them the power to be there, directly or indirectly. And so if the public is hammering on them and pushing on them and being polite about it, but demanding that they be involved in the decision-making process, you get a lot further. And what I was starting off with, and I'll maybe end with it because I think we're probably near the end, is a real pitch to you to realize that you can't have an honest government unless there are really organized political activity coming from the community. Because otherwise, you're treating the government like it's some existing entity that exists independently of us, and they will reject the public, because as soon as they start realizing they are the county, they are the water agency, they want to do it their way, and whatever that way that is, and from their own personal biases and their own personal interests, because we give them all of the power. They don't, there is no reserved process that says these 5 supervisors can do a lot of things, but they can't do these things. They can do anything that is within their jurisdiction. The plenary police power gives a local government the right to do anything, which is why I never let them tell you they can't do it, because they can do it. It may be hard, but they can do it. And so once you give that power away, and we do that, that's our system, is we give it away to these elected officials. If we then sit at home and watch The Good Wife and don't, do anything else, we're not going to have good government. And that's really what keeps the government honest, is the kind of informed and engaged political activity that the League sponsors, that the Fort Ord people do, Land Watch does, that those are the things that make our government honest. The tools are these laws that we've set up, and they're actually quite powerful, but only if you got people willing to, because it takes time, it's hard to do, it's not easy. But what is our purpose in life here? From my analogy, is our purpose in life, since we're building the world, our own human world, and we can make it any way we want to, there is no inevitability about anything, that really working with others in our community, the people we know and see, to make things better for us, for our children, that's what life is all about. I mean, it's not about getting more money, it's about building a world that's decent, honest, and honorable. And we got to be engaged. Thanks. Yeah.